Hello and welcome to the Periphery from the Pulaski Institution. I'm Alan Elrod, joined again by Bailey Fairbanks. We're going to be getting into a few different things. As you know, Bailey has a background in the U.S. courts and legal systems, so we're going to be definitely doing a lot with that. And we have an interesting kind of segue into that topic today, which is we've had a lot of news in the past few days about the Mifepristone case that made its way to the Supreme Court.
Mhm.
And one of the silver linings, I guess, that people have taken away right now is that it looks from the actual arguments that we saw like there's a decent amount of skepticism on the court about whether or not these plaintiffs have standing. Uh, the reason that's interesting for us today is it gives us a chance to talk about how this case got here in the first place, which is a problem in the American court system that's becoming pretty pervasive, right? Which is judge shopping. In other words, we got here because of a district court ruling
Mhm.
uh, in Texas that was basically shopped, right? They went and picked where they wanted to fight this case, and they got a ruling that they wanted. And then now we're going to have a national court battle at some point, right? Because even if this case does get thrown out on standing, that's not really going to be the end of the story. We're still going to be stuck with the fact that there is an ongoing legal battle about access to this abortion drug. But I think before we talk in this episode about just the democratic and liberty implications of a mifepristone ban, if it were to happen, I want to talk first about this wrinkle, which is an American problem, right? Because of our system, our federal system of judge shopping, and and how it presents an opportunity to kind of game the courts to get favorable rulings, and in situations where these cases reach the Supreme Court, potentially really shift constitutional precedent uh, in big ways. So can you talk to me a little bit about like the journey of this Mifepristone case? The Supreme Court currently looks like it's going to throw this one out on standing, but
Mhm.
how did we get here in the first place? How did we get from this initiative in Texas, this ruling in Texas to the Supreme Court? Unpack that a bit for us so we can understand a little bit about this case in particular, and then also just sort of what judge shopping is and means in the American system.
Mhm. So there's a couple things, and you mentioned this, and I guess really does like a great continuation of the conversation that we've been having just generally about, um, you know, reproductive care, abortion, right? All of these discussions. Again, like you said, this is my area, my wheelhouse in talking about all this. So this brings up a lot of issues as far as everything goes. The first issue, right, is this idea of standing, right? Like you said, the court does seem pretty poised to deny standing in this case. And standing is an important issue, right? Having standing in a case, which means, the individual who's bringing the suit has, insult or injury, right, related to this legal grievance. Um, has always been an important factor, right? And the court has dealt with, right, many cases, but we're seeing this issue of standing in itself come up more and more and more. The case and the courts facing so many cases, not just this one, right? We can look at same-sex marriage, right? We can look at the cases in Colorado with, the bakers and the wedding websites, right? So there's cases there. We've also seen it, right, with same-sex marriage even earlier than this, right, and other issues. You're right, the question of whether or not a group, right, an individual, a group can bring standing. And knowing about standing, right, we can historically look at, right, the role that like interest groups have played in, being able to bring cases to the court. Some of the most, historical decisions, right, Brown versus Board of Education, right, was the ACLU essentially shopping for individuals so that they could bring suit because they knew as an interest group, right, they didn't have standing. They had to have somebody, right, a plaintiff in the case that had this insult and had this injury within all of that. And so this case is brought up, right? In particular, this case being brought against the FDA. The Alliance for Hippocratic Medicine is arguing, right, that they have the authority to bring this case before the court because, right, their doctors, right, the emergency room doctors and doctors that are represented by their style, would be, right, forced to, right, perform medical services on individuals that have taken mifepristone, which then, of course, in and of itself is that doctor endorsing this idea of abortion and having an abortion and providing access to an abortion. And so the question is standing there. And again, the court has seemed extremely, extremely skeptical about that. I think both sides, both conservative and liberal, right, identified judges having that position. But it also brings up, right, this case, this great idea and this discussion of judge shopping. And I know we've been kind of dancing around it, you and I, in our conversations about what this is. And that's this idea of, right, when the courts are, or cases are making its way through the court, we have to go through a series of courts, right? You can't just make a decision, right? A law can't just go into place and the Supreme Court decide to hear it, right? The case has to be brought into a court, right, within all of these circumstances. And of course, within the federal system, right, those cases start at the district court level. But one of the requirements, of course, is that the violation is happening, right, within the jurisdiction of the court that it's being brought. In this case, you're talking about the application of a law that has been put in place by the FDA, right, or a standard that is being put in place by the FDA, right, the authorization of the use of mifepristone. Jurisdiction doesn't really become a question because the FDA, right, covers the entire United States. So they could bring this case anywhere, right? They can bring this case in any court in any circumstances. What the groups have done, not only with this case, but with other cases as well, is that they've picked a particular court, right, in a particular area, right, with a particular judge, in this case, a specific judge in Texas, right, the North Texas District Court, right, that he was appointed by President Trump, right, and they brought the case to his court, right, where he is the only judge to hear these cases. And knowing his ideology and knowing that, they put the case on his docket and they got the decision that they wanted. Right, they got this injunction, and it went even further in that traditionally the jurisdiction of a court is just that, right? It's geographic district, but this judge in particular went a step further and actually put an injunction in place that's a national ban. Now, of course, right, the Fifth Circuit stepped up, right, supported that ban, and then the Supreme Court has stepped in multiple times, like during the time after taking this case, to say, no, we're putting that ban on hold. So, side note, still can get mifepristone, still have access within all those circumstances. But, right, it's this problem that, right, these groups and individuals, right, where formerly you had a much more difficult time, right, being able to bring cases before the court because you had to have that insult or injury, you had to have that standing, you also had to fall within that jurisdiction, and you had to, right, deal with courts that had more judges on them. Right? Don't have to do that anymore. Right? The system and the institution has built it that way. Now, one good thing about this, and something that happened a few weeks ago, is actually, right, the federal courts have stepped up and they've now put rules into place, or there are proposing rules to be put into place. The rules themselves haven't gone into place yet, but is to prevent this judge shopping from happening, which is that they are putting standards into place so that cases can't just be brought into these districts where there is a singular judge. Right now, it's going to be put into, they can still be brought into the district, right? But the judges that would oversee it are actually being pulled from a pool of judges. And so that's one of the new proposed rules, right, to try and overcome this issue of judge shopping. But again, this case, this mifepristone case, was brought right into this specific court to this specific judge to get the exact judgment that they want here.
I want to get into the mifepristone stuff in a little bit, but I think the big thing that this opens up for us at the outset is just this problem that we do have in the United States, and not just the United States, because other Western democracies are dealing with this, but in the United States, we do have genuine assaults on democratic institutions. But what this gets at is the problem of people playing technically by the rules. right? This is not actually, no one is violating the law here. No one is. Now, the Supreme Court could look at it and say, we don't actually think you're injured by this law. We don't think you have standing, etc. Right? But that's a very common thing that happens. People bring a
Mhm,
case, and sometimes courts say, actually, we don't think you have the standing to bring this case, and that's it. That's a normal. That's the process working. Um,
mhm,
so this thing with judge shopping, and particularly the way it's been gamed by pretty conservative groups.
mhm,
Right, as you mentioned, long history of doing this across the political spectrum,
mhm,
but right now in the United States, it's pretty popular on the right, to try to get
mhm,
favorable rulings on some of these particularly on some of these social issues. But this is a serious, I think it raises really critical questions about the way democracy works and how you can have essentially threats to a system that come entirely within technically the boundaries of what's legal and allowed,
mhm.
right? So from a legal perspective, I mean, judge shopping, like as a practice, has roots in, right, completely normal democratic principles.
Mhm. Yeah, so it's and sorry to clarify in relating it to like Brown and those things, I wasn't saying specifically that the ACLU was judge shopping. They were plaintiff shopping. Let's be clarified, and that's different, right? They were trying to find someone to be able to bring the suit right as a plaintiff.
Right.
Right. This is moving beyond that. This is now we've not only found a plaintiff or we've created a plaintiff that
Yeah,
thinks
that's the
that
other
they
thing,
have
right? This
standing.
organization was basically founded,
Right.
uh, Hippocratic medicine was basically founded for the sole purpose of bringing this case.
Right. Sole purpose of bringing in this case. So they both plaintiff shopped in, well, literally plaintiff originated this case, and then shopped for a judge. Right. So they've put everything together in the box, and they said, this is what we want, this is what we're gonna get, and we're gonna make it the exact way that we want it to do. Right. But so again, like you said, it's not breaking any laws, it's not breaking any things, it's a perversion
Mhm.
of these principles, and that's the bigger question in all of this is thankfully right, at least to an extent that the federal courts are stepping up to put these new rules or future rules into place, right? As a discussion, we've seen a lot of that happening in the court systems, right? Not only these new rules at the federal level, but also right this new ethical code that's been put into place, right, for the Supreme Court. But the fact is that like our institutions have existed for a long time without this.
Mhm.
And now we have all of these things coming down the pipeline. Right
Yeah.
now, all of these things are coming to head, and the courts and institutions in of themselves are having to face that problem because the level of scrutiny that they're under now is so much higher. Right? I joke all the time that I studied courts because, for the most part, they were the most nonpartisan of partisan institutions. I definitively can't say that now. Right? Like there is no way. In fact, hyper partisan just as much as right these other institutions. Right, but with less of that base.
We talk about this phenomenon when we're
Mhm,
talking previously about the current ongoing Trump cases and about
mhm,
how obviously part of the dynamic in these individual cases is which judge each case happens to have found itself before.
mhm.
Right? And
Yes.
obviously, we've seen very different approaches in the different courtrooms. Right? We're
Mhm,
seeing, you know, quite a lot of, I think we could just call it sluggishness, maybe, out of Florida. I mean, Cannon is not moving quickly, right?
No.
And that's a lot of power for one judge, and they very much, it's not. This is a situation, obviously, where the federal government uh, had to bring the case in. Probably they could have brought it maybe in New Jersey or or elsewhere, right? But South Florida was made sense. But then you have this challenge of, well, you got a judge there, Trump appointed. Some of the problems with how this is being handled may just be lack of experience because we know that she's never handled a case like this before. But
Hmm.
also like when you get these sort of when she takes a really long time to review a particular appeal, and then she gives a kind of like three shuts the door like three-quarters of the way on things where it still seems to be leaving things open for more appeals and more foot dragging, right? There's a very slow moving approach that Judge Cannon is taking.
Hmm.
And it gets at the same thing we've been talking about, which is
Absolutely.
this dynamic where which courtroom you find yourself in really matters. And in theory, that's not supposed to matter, right? It's not supposed to matter what courtroom you find yourself in.
Hmm.
Uh,
The law is the law, and it should be
right.
the same everywhere.
It's not, and the only place where it can get changed is the Supreme Court, right?
Yes.
That's the only place where really we should, we're talking like, I guess, the circuits and district courts have a role to play in being provocative potentially to send things up the pike. But still, right? In theory, there's not supposed to be this much, right? We don't actually want there to be this
Yes.
much potential variance with which judge you find yourself before, especially when we're talking about implications like, obviously we know that the extreme implications of the Trump trials, but this Mifepristone case as well, right? We're talking about the potential for a nationwide ban on an abortion drug, which is huge because, and this is, I think, where we can pivot into the implications of this case, because
Mhm.
the worrying part of this is the Supreme Court looks like it's ready to kick this back on standing, but that doesn't mean they can't bring it again. And that also doesn't mean that the court is necessarily hostile to banning mifepristone. This is sort of a technicality, right?
This
This is
is.
not like anybody looking at this and saying mifepristone is safe. It's not really the impression I have from the legal coverage I've read. The impression I have is this is not a clear cut win where we can all go back to not worrying that this ban could still happen.
Yeah,
Right
because
now,
there's nothing stopping someone that actually does have an actual issue with this from bringing another case. And
exactly. And that's probably
and
what they'll find next. And right now we have a bad situation in the United States where we have this federal patchwork of reproductive rights. I think that is, we've talked about place-based democracy at Pulaski all the time. We argue that actually, if someone's civil and democratic liberties are being deteriorated where they live, that matters. Just because you can leave Texas and get an abortion in New Mexico, it actually is important that burden is now on you to do that. But still, that is a different map of rights than if this pill is banned.
yes.
So let's talk a little bit, if you can walk us through
Mhm.
what it would actually mean or look like if we end up, because we still could yet get a mifepristone ban. And if we get that, what does that look like?
I mean, so like you're saying, there is every indicator from oral arguments is that, all of the not all sorry, let me pause myself. Not all of the judges are skeptical. The majority of judges or justices are skeptical in this case. We've always got Alito, hanging there in his diehard way.
Leo and
Um,
Thomas, never skeptical.
Yeah, I
Uh,
mean, talking about Comstock and bringing up the Comstock Act, right? Laws that were put into place in 1880s, 1890s. Those laws still matter. Because the question and part of this case too is, of course, that from the context they've loosened the restrictions. So of course, right, the Mifepristone case and the basis of it and the challenge to it is that the FDA went about this improperly. They went about not the approval necessary process for the judge, but they went about loosening the restrictions for the case in and of itself. And then, of course, the question in and of itself is that right, and the doctors at hand in this case that are bringing this case are saying that if they have to deal with a patient, right, that is dealing with complications from mifepristone, right, that is they have the option of, or they feel like they don't have the option to engage in a conscientious objection
mm,
to its use. So, right, in this instance, right, the FDA approved mifepristone in 2000, right, requiring doctors' visits and all of that. It was a 4-year endeavor, right, to improve mifepristone as, right, this pairing of drugs, right, mifepristone and mifepristone being the second drug in the series that is taken. Now, one thing to say about this is that this combination of drugs, right? By technicality, a woman could still take the second drug, still undergo this procedure. It's just much more likely that there are complications, right,
Okay.
tied to it. Also, right, the second drug in and of itself, they're not going to be able to tackle this the same way, because that second drug actually has other medical uses. So they can't pull it off the market, right, the same way that they can. But what mifepristone does, right, is makes this process much easier, right? It makes that idea, it extends, right, the ability for a woman to be able to have a non-surgical abortion out to 10 weeks of pregnancy, where formerly it was only 7 weeks, right? 7 weeks, of course, most women don't even know that they're pregnant. Not that 10 weeks is much better, but still,
Yeah.
in those circumstances, right, it changed that dosing that they required again for that extended time. It also, right, allows, and the biggest change was that women don't have to physically pick the pill up, right? They can actually get this pill delivered to them by mail.
Okay.
So that's a big part, right, of this, and that's a big challenge to this case, and that's where I was joking about Comstock laws, right? These Comstock laws were laws that were literally passed to ban the distribution of contraceptives through the mail, right, and through federal mail, and very, very outdated. Lots of states have them. The federal government still has one on the books, and it's just not been enforced, right? Because to some extent, right, we're not living in the 1870s, 1880s, 1890s. Although, ask a woman these days, and that's a little debatable. Sorry, not sorry that I said that. But in those circumstances, right, the Comstock laws were the reason that, right, we got Griswold v. Connecticut, right, because that was of course what they were challenging was a Comstock law in the state of Connecticut, right, for the access to contraception. Right, and that's how they initially passed this law, but that was a state-based law, that wasn't the federal Comstock law in those circumstances. Within all of that. So, right, there's so many questions about this. Of course, to note, and this is a statistic everybody knows, is that, right, 60% or anywhere between 60 and 2/3, so 66% of women that have had abortions in the last year have been as a result of the use of mifepristone, right, these non-surgical options for abortion. And so by cutting off access to this, right, like you said, we're not just talking about the impact that they have on red states, right, where abortion access is already massively restricted. Now you're talking about infringing rights on blue states where, right, that access has not been denied. And in fact, in some states, that has been constitutionally protected. But they are attacking it no longer from the state aspect. They are attacking it from the federal aspect and looking at the FDA. And by attacking the FDA's, right, admission to this, it cuts off access everywhere. Deep
Well,
breath.
yeah, no, I think it's a grim prospect. Obviously, we would still need to see a new we're probably gonna, I mean, they haven't actually ruled, but we're probably have to see something new be brought in order for this to happen. And in the interim, we could see the government enshrine. It would take a changing of control of the House, but we could still see something like further abortion rights enshrined legally from the national government. But still, I mean, with Republicans talking about a national ban, I mean, really, if something like this gets implemented, you have effectively, I don't think it's hyperbole to say you are really making abortion practically, uh, if not impossible, very difficult for many people. Um, and that is part of the goal, I assume.
Yeah, I mean,
Uh,
absolutely.
so it's not. I think this is the thing that, right, there's the legal approach, which many people will say, well, I don't think we really need to be worried about them passing a national ban, and I would argue, well, there's a chance they would,
Mhm.
uh, but there's also other ways to achieve very close to the same results,
Mhm.
and a mifepristone ban is certainly going to get them pretty far.
Yeah, and I mean, but
Um,
again, you're talking to people saying that they're probably not going to do it, right? But that doesn't mean that we can't, and to some extent, right, can't be prepared for that fact. And
or
and they said the same thing about Roe. right? They said that Roe was never going to be overturned.
Right.
And here we
Oh,
are.
yeah. I'm not dismissing those fears. I think it's
Oh
entirely
no,
possible
absolutely.
that a ban will get put forward with real bite.
Mhm.
But um,
But to say all of this and to say that I actually didn't even think to mention this until I was just sitting here and I was going, we've been talking so much about this and we've been talking so much about the IVF case, at least in previous episodes. I forgot to mention about Maryland Lands. Right, Maryland Lands winning the Alabama special election state house seat, specifically by running right on reproductive rights, right, flipping a seat in the Alabama state house this week, in particular, right, for her protection and her discussion about the Alabama IVF case. And so, right, we know, right, this is impacting. We know that, a lot of conservatives in the Republican Party have been pushing, like, trying to get right these topics and these things off of the radar because they did have such an impact, right, in the midterm elections. But it's still prevalent. It's literally still happening this week, right? Mifepristone, in this case in particular, could be right. And I want to say it's the next Roe versus Wade, but it is right. It's got that same level of implication. And I know that's
well,
what we've been talking about.
and I'll highlight here as well. This was featured in one of the headlines from the Heartlands Roundup this week. But Susan Davis, who's at Michigan Advance, uh, wrote a great op-ed talking about um, not just obviously abortion and IVF, but even surrogacy law coming under fire from some on the right. And this is, I think, what we have to deal with is we are in a moment where there are a number of people, and we could even say they're in the minority, but still, who are interested in completely restructuring the way we do reproductive rights and the way laws around reproductive rights work. And we mean that in a more holistic sense, not just abortion, but a lot of other things around reproduction, IVF, and surrogacy. And I think what this case and talking about judge shopping highlight is similar to the challenges of, say, extreme gerrymandering and kind of, uh, you know, things that empower, right, large majorities in states where maybe one party's not, Republicans aren't actually receiving that a reciprocal amount of the votes. What this all really gets at is, even if it is a relatively fringe amount, there are completely within the bounds of our system ways for those and aims to be advanced. There are ways to advance even fringe ideas through our system and get them implemented.
Mhm.
Um,
I think, even more poignantly tied into all of this, look at RFK Jr. picking his running mate this week, right? Nicole Shanahan. That's another right tie into all of this. And as much as people say that, he doesn't have a chance in hell and blah, 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 right? He picked a running mate that's giving some of these positions legitimacy,
right.
right? Like
And who has
she,
the money to put him on the ballot in more
right,
states because it's
right, and has
expensive.
the
People don't
money.
understand it's an expensive and time-consuming process to get on the ballot.
Mhm,
So, um, he's like, the RFK threat is certainly more of a spoiler threat than anything else, but it matters.
mhm.
Um,
it,
yeah.
it, it
So,
like I said, it matters for the conversation. And in my case, talking, or in our case, talking about what we're talking about, right? She is a adamant, right? Adamant advocate against, right, the use of IVF, right? She tried IVF, IVF didn't work for her, and so she said, we should go about it naturally. And then, of course, she naturally conceived in all of these circumstances and things. So, but again, it's these fringe positions that are becoming and having this legitimacy in this discussion. So,
all right. Well, that was a good chat. Well, it was a discouraging chat, maybe.
they're never good
Um,
chats. Let's be
we'll
real. Like,
we'll be back next week, me and Bailey, and a week after that, we bring again start some special guests. I am excited for some of the episodes we have lined up. We'll try to go back and forth between bringing in guests that really let us have kind of interesting conversations about really neat particular topics that let us dig in, and then also doing these episodes where Bailey and I try to do something that's topical on a regular basis that gets it to like things that are in the news cycle. Um, Please, if you can, subscribe, and rate and review us. We're on Apple. We're also here on YouTube if you're watching this video. We're on all other podcasting platforms if you have a different preference to those. Also, if you want, our Substack is Headlines from the Heartlands. You can find that via my personal Substack profile, Alan Elrod, or searching that. It is where we now put out our headline roundup, which includes usually 3 stories Monday through Thursday about places in the US and abroad, developments in Heartland places with analysis by me. And you can subscribe via Substack, or you can go to our website and click on the Headlines from the Heartlands link there, where there is an embedded Substack subscription link on that page as well that you can use. So that all helps us. But big thing is making sure that you click like or rate, review, all those things. And we will be back next week. Thank you so much for joining me, Bailey.
Thanks, Alan.